Good evening. I'm Rabbi Sue Shankman of Washington Hebrew Congregation, and I'm happy to welcome you on behalf of the congregation. And we find ourselves here this evening in the midst of the Jewish festival of Sukkot, a time when we reflect on the fragility of life and give thanks for our blessings. It's customary for us to build a temporary structure, a sukkah, and usually we have one right here on the bima. We moved it temporarily to make room for this evening's program. It'll go back up later. And it recalls the harvest time when our ancestors would dwell in huts. There is a tradition in Judaism of welcoming ushpizin, honored guests, into our sukkah. Thus, it is our pleasure to welcome honored guests this evening as we host a conversation with Professor Mohammed Wattad and Dr. Aryeh Dubnov. Professor Wattad is an accomplished legal scholar, constitutional expert, dean of law at Zafat Academic College, both the youngest and the first Muslim dean in Israel, and an Arab citizen of Israel. And Dr. Dubnov is the Max Tickton Chair of Israel Studies at the George Washington University, the author of several publications on Judaism and Zionism, and a Jewish citizen of Israel. And the conversation will be moderated by our good friend, Dr. Lauren Strauss, scholar in residence and director of undergraduate studies in the Jewish Studies program at the American University. And all those students who are here who just did that little woo, extra credit, right? It is not often that we have the opportunities to hear about, much less from, Israel's Arab citizens. Yet issues related to Arab citizens have increasingly been considered some of Israel's most important domestic priorities. On the whole, Arab citizens are by far the most economically disadvantaged of Israel's populations. The large gaps between Arabs and Jews have come to be seen as a major economic concern for the country as a whole. In recent years, the Israeli government has made dramatic investments into economic development for Arab society. In addition, as the government is working to encourage Arab integration into higher education and the labor market, the headlines are also full of tough exchanges between Jewish and Arab politicians and exclusionary statements by some government leaders. And one of the most stark and recent examples of this has been in the wake of the nation-state law passed by the Knesset this summer. The nation-state law has sparked significant debate about Israel's Jewish and democratic character, much of it with respect to Israel's Arab citizens. The reform movement expressed serious concern, Rabbi Rick Jacobs expressed serious concern that the nation-state law will do enormous damage to the legitimacy of the Zionist vision and to the values of the state of Israel as a democratic and Jewish nation. We take pride in the description of Israel as a Jewish and democratic state and recognize that there's a fine balance needed to maintain both those characteristics. Arab citizens, at 21%, is the largest non-Jewish population of Israel and represent the greatest test of this balance, as well as Israel's democratic commitments. So we have questions that we ask ourselves. What are the mutual obligations and commitments of a Jewish and democratic state and its non-Jewish citizens? What is the current status of this balancing act, and what are some of its biggest challenges? What are the implications for the Jewish community in the diaspora and our relationship with Israel? Tonight, we are privileged to hear expert and inside views into these issues from an accomplished legal and constitutional scholar and a distinguished historian, both of whom will speak from personal experience as Israeli citizens. Though we may not be standing inside our sukkah structure, this entire room is our Sukkot Shalom, our shelter of peace for one another. Each of us who is present share in the obligation to maintain that shelter of peace through the civility and consideration we demonstrate towards one another, both in how we listen and how we learn and how we ask questions of one another, that we might learn and grow and move forward together. So please join me in welcoming our guests as well, and welcoming a good friend of Washington Hebrew, Dr. Lauren Strauss.
Thank you so much, Rabbi Shankman. It's always good to see you and good to be here. I'm kind of missing the fact that there's supposed to be a sukkah on the bima, which I've never experienced before, so I'm sort of sorry to miss that indoor sukkah experience. And welcome to everybody. I'm so glad to see you all, and I'm glad especially that you didn't drown on the way here. And yes, those of my students who are here, I do know who you are, and and it won't be forgotten. Right. Tonight's turnout shows us that there really is an unprecedented, unusual level of interest, even outside of Israel, about this new so-called basic law. And Dr. Dubnov will be explaining what we mean by basic law. That the Knesset, Israel's parliament, passed in July this past summer, after years of discussion and debate. So that's one thing that should be known, that even within the current Knesset, this did not happen easily. Although this evening's program will focus primarily on one major aspect of the new law, arguably the most controversial aspect, its ramifications for Israel's largest minority, its Arab citizens, the law's impact reaches far and wide, affecting relations between Israel and world Jewry, as well as raising questions about the future of Israel's democratic character within the state's borders. Before I turn to our distinguished panelists, I want to again thank not only Rabbi Shankman, but Washington Hebrew and its staff, especially Lainey Weiss, for their extremely generous offer to host this evening, and all their help with logistics. And of course, Laura Katz-Cutler, as always, there she is in the back, of American University's Center for Israel Studies, for her logistical help, in particular the important task of collecting RSVPs. And I'm sorry to be missing my colleague, Michael Brenner, distinguished historian at AU and director of the Center for Israel Studies, who was supposed to be with us tonight, but had a problem getting here. We also, of course, thank all of our wonderful co-sponsors who are listed in your program book. And if you didn't get a program book, please make sure there are plenty of copies, that you get one in part because of the lovely pictures, of course, on the front, but also because it has inside it the text of the actual law, the text translated into English, and this is the official government translation into English. So it's good if you have that. Finally, I want you all to know that this event really would not have been possible without the tireless efforts of Allison McWilliams, who is also in the back, executive director of the Naomi and Nehemiah Cohen Foundation, who are co-sponsors of this evening, and she's coordinator of the Greater Washington Forum on Israeli Arab Issues, which I'm privileged to serve as co-chair along with Rabbi Bill Rudolph. Finally, a few points of information. First of all, I just want to make sure that you're aware that the Embassy of Israel was invited to join us several times, actually, to participate in this evening's panel discussion. But their representatives were quite busy this season, and so that is why they're not here. Second, we expect and hope that there will be questions from the audience for our speakers. And the way that we're going to conduct the Q&A session is that Allison, who you can wave standing in the back, is pointing at students. Okay, she's pointing at a student with a basket. See student exhibit A, student with basket standing in the back of the room. We will provide index cards for you to write down any questions that you might have. Please try to be legible on the index card. And then we will collect them and ask the questions from the cards, which is, of course, the most efficient way of getting as many questions in as possible. Finally, if you would like to continue the discussion after our time here is over, and I hope you do, please join us for a post-panel reception in the Krieger lobby, the main lobby of Washington Hebrew, which is not the location printed in the programs, but frankly, it'll be pretty obvious where people are headed, so in the main lobby. And I also want to thank Washington Hebrew and the Naomi and Nehemiah Cohen Foundation for providing the food for the double reception before and after the event, because, hey, when you're dealing with Jews, If you can feed them once, you can feed them twice. Now, for this evening's subject, as you know, we are going to be discussing this new, widely discussed and debated law that really has made it into all forms of media outside of Israel and was discussed at great length in the common newspapers and on social media and online across the world, especially here in the United States, and which became Israel's 15th basic law after it passed by a vote in the Knesset of 62 votes in favor, 55 against, and 2 abstentions. So this was really a close vote, and as I said, as Dr. Dubnov will talk about in greater detail, this was really after years of discussion and debate on this topic. The debate itself that ended in the vote in July apparently was very stormy, full of theatrics. Can't imagine that in the Knesset, right? And the debate itself stretched more than 8 hours, and the voting lasted more than 3 hours. And after it passed, Prime Minister Netanyahu applauded the vote's passage, describing it as, quote, a defining moment in the history of Zionism and the history of the State of Israel. Well, it may be a defining moment in the history of the State of Israel, but there are, of course, different opinions about exactly what it means for the State of Israel and also for the perception of Israel and its democracy around the world. I'll mention a few points a little bit later on after we hear from our speakers about the other major aspect of the law that has been discussed in this country, and that is its ramifications for Jews in the diaspora. But I'd like to first hand the microphone to, or actually, he has his own microphone, to Dr. Ari Dubnov, who will speak first in his capacity as historian, as you heard, holder of the Max Tickton Chair of Israel Studies at the George Washington University, and then to Professor Mohammed Wattad. So thank you.
Can you hear me? Hi. Good evening, everyone. Thank you, Lauren, for this wonderful introduction. Thank you for all the many good souls that I know worked hard behind the scenes in making this happen. And thank you all for braving the awful weather outside to come. And it's an honor to be ushpizin in this little virtual sukkah. And as it was mentioned, I'm a historian. I'm not a legal scholar, so I'm not trying to pretend that I know the fine grains of legal analytical reading of the law, and my comments will be basically based on my reflection as a historian of Zionism and as someone who follows current events in Israel. Now, it's crucial to, before going into detail, and I was glad to see that the program in front of you has the English translation of the law, because I will be referring to a few of the clauses that stirred more controversy or that people turned their attention to. But before going into that, it is, I think, important to remember that we are not talking here about a regular, ordinary law, but a basic law. And the term is slightly tricky because there's a bit of a historical backstory here to begin with, and the one having to do with what Israel lacks, meaning a constitution. There's no written constitution in Israel. Those of you who were careful students of history may remember that even in the Israeli Declaration of Independence, there was a clear decision that the People's Council would elect a constitution assembly, what was called Ha'asefa Mechonenet, that would prepare a constitution. They even have a specific deadline, October 10th, 1948, and like myself, when submission deadlines come, they missed the deadline. There was never a constitution. There were few proposals that were circulating, but they were rejected. They were discussed and rejected. It was a funny thing that earlier this afternoon someone asked me, so whatever happened with these proposals? And I didn't have a good answer. I went online and I realized that Kedem Auction House you can buy one of these for $400 if you're interested in seeing some of the proposals for a constitution that were discussed and then rejected in 1948-49, including a very interesting one that thought about modeling the new state after the Irish constitution, for instance, and things like that. So these are the things that are left on the floor of the editing room that interest only us, the historians. But what is important to understand is that in a complicated process, what Basic Law became, if you'd like, the very imperfect substitute to a special status laws that are the closest one can get to a constitution or an amendment to a constitution, but they are not, of course, a product of long deliberation of a council of wise men or group of philosophers or founding fathers. And in that respect, it's really important to remember that Ben-Gurion was no Jefferson and Jerusalem was no Philadelphia. And basic laws are passed through the Knesset through a political process of push and pull, and they are chips in the political game in a country that was very fraught from its very early years. Now, the legal experts again will be better equipped in explaining what exactly makes basic laws superior to ordinary laws, yes or no, but it's really important to remember that, of course, there are several basic laws that were passed before the current law, and when we're moving beyond the realm of the Supreme Court and the legal experts, and we're talking about the popular public opinion and the way politicians are playing with these laws, often basic laws were colored with a very specific ideological, they had a very specific ideological tint on all spectrums. So in the 1990s, when under Yitzhak Rabin, the government passed a famous human dignity and liberty basic law, it was the public perception or the way it was often portrayed is that this is the left camp that is promoting its own agenda. And then people that were more inclined to follow, that are supporters of the right political, end of the spectrum in Israel, would prefer to have, for instance, a minimalist interpretation of that law. Now, when the conditions changed radically, I won't be surprised if the same people that would have had a very minimalist interpretation of the 1992 law will be very happy to emphasize a more expandatory, maximalist interpretation of this current law. So you have to remember that the political industry that produces these laws is a bit different from what you would expect from a traditional constitution, but at the same time they function almost like an unwritten constitution. Now, from these prefatory notes, so not knowing the law, as we all know, is not an excuse from punishment. We need to know the law itself and why exactly it steered such a controversy. And one of the big problems in discussing it, and this is exactly what you won't find in the program, even if you look at a very careful English translation of the law, is that much, or if not in a sense, I think so many of the debates and the polemics boil down not to what the law says, but exactly on what it lacks, on what is not included in the law. Meaning the law will be open to future legal interpretations, and the law states, has many statements about Israel being a Jewish and democratic law, but traditionally and historically, so many precedents will always add another clause that will say, and at the same time, it will protect the equal rights of the non-Jewish residents of Israel. Now, and if you look at it again from a perspective of a historian, and you look at earlier documents, and even if I'm going all the way to pre-statehood years, and I will go as long as 100 years back to the Balfour Declaration, that had a very vague and ambivalent phrasing and was far from perfect. Even that included, I'm paraphrasing, that nothing shall be done in which that would prejudice the non-Jewish residents of Palestine. This formula then replicated itself with slight variations into the mandate on Palestine that was affirmed by the League of Nations, and then found its way into the Declaration of Independence of Israel that states very equally that it will ensure the complete equality, social and political rights for the non-Jews. So part of what made so many people not happy about the law is exactly that it lacks these type of qualifications, these kind of promises for equality and democracy. So in a sense, part of what is tricky about understanding the polemic in Israel about the law, it's a bit like the famous Arthur Conan Doyle story, the dog that never barked. There's no, I mean, everyone was looking that in addition to statements about Israel being a Jewish state, it will also add, and then also, and this and also never came. Few clauses that sparked, more focus, more, sort of 4 significant points that I will make that I saw people referring to them back and again are the following. The first one has to do with settlement. Now, the law includes a section dealing with settlement, and it states, and this is my translation, I apologize, I translated it crudely from the Hebrew version before I saw the official English translation, so there might be slight differences in nuance. The state views the development of Jewish settlement as a national value and will act to encourage and promise establishment and consolidation. המדינה רואה בפיתוח התיישבות יהודית ערך לאומי ותפעל על מנת לעודד ולקדם הקמה וביסוס שלה. This is the Hebrew version. Now, to be sure, the value of settlement existed both in the Declaration of Independence and before the establishment of the state. However, the clause in this new law has an operative essence, not just a symbolic one, and it is hard to see how it does not establish some kind of a discrimination. The new law states that only Jewish settlements have value. It doesn't say any settlement, and so it might be interpreted as discriminating against someone who wants to have, establish a new Druze or Christian or Muslim settlement. Now, does this mean that the state will be able to establish Jews-only settlements? This is, of course, not clear. Part of what happens here is that we have a new situation that allows future justices to interpret the law in different way. But the priority seems to be very clear to advance the settlement of one group over the other. Maybe some of the arguments that are being made that part of the precedents that those who were drafting the law had in mind were, we might talk about it later on, cases like Bagatz Kadan Katsir, when Arab families tried to join Jewish communities and pass through selection committees, they had big problems doing it, and they appealed to the Israeli Supreme Court. And in a sense, maybe part of what happens here is that you will have a legal mechanism that will allow Jewish settlements or mitzpim in the Galil or villages to find a legal mechanism that says, we're sorry, but the law allows us to say this is a Jew-only settlement. And this is before we even use the word settlement on that area east of the Green Line, where this law is very, which is a different territory legally. Now, the second point that raised a lot of attention is the reference to United Jerusalem. The law declares, again, you have the text before you, a complete and united Jerusalem is a capital of Israel. Now, there's a bit of a funny thing about the popular reaction to that specific clause, because it is, for those of you who might remember the days of Menachem Begin, it was one of the biggest achievements of the Begin administration, the government, to pass in 1980 a basic law that exactly said this. So in that respect, it's a good example of the short, memory span of so many of us. And the statement was provoked a lot of reaction, much due to the timing in which it was uttered, very close to President Trump's decision to move the embassy to Jerusalem. But a more interesting point that critics raise has to do not with the repetition, but with the reference to United Jerusalem. And United Jerusalem, of course, assumes that you are including East Jerusalem, an area that was occupied in 1967, that is not recognized by United Nations or the international law, and consider it as part of Israel. So you're doing here something that is very problematic, and it also may create a situation in which, even if a future Palestinian state will be established, it won't be able to say East Jerusalem is our capital as well. So this is part of the debate about this specific clause. In a sense, many would say it codified in law what was already a process of erosion of that respect. So the two last points, the question of the Arabic language. The new law stated that the Arabic language has a special status in the country, and the legal and historical interpretation of this section are required, I think. It's enactment, again, of pre-state laws in the British mandatory period. By mandatory, I mean mandate Britain that controlled Palestine before 1948. There was a very clear legal mechanism, the King's Word in Council, which determined that Arabic and Hebrew are of equal status. When the State of Israel was established, basically so many of the British laws were enacted again. So in a sense, what changes now is that suddenly the legal code gives Arabic a weird status by calling it special, and no one really knows what special means. Now, I won't go into the acidic irony of from a Zionist perspective, that for Zionism, the revival of Hebrew was so important. Whether it's true that if it is indeed true that the intention of the legislator was actually to suppress Arabic as a spoken language in Israel, it's a bit of an acidic irony here, that a national movement that made Hebrew language and its revival so central is so busy suppressing other languages. But what is important to remember here is that for many Arab speakers in Israel, they argue often that the new law prepares the ground to a future legislation that will be more draconian and explicitly discriminatory, or, for instance, that if they will come to an official, office of government, and they will ask, I don't understand here in Bituach Leumi, I don't understand what you're saying because all the signs and the memos are in Hebrew, I'm asking to get also an explanation in Arabic. They'll say, we're sorry. And by de facto, you will discriminate. I mean, we are not obliged by law to give you a translation. So this is part of the argument. Now, in short, the Arab citizens in Israel can often feel that this is actually preparing the ground to something worse. So they can be accused of paranoia But as Woody Allen famously said, the fact that just because I'm paranoid doesn't mean that no one is there after me. So this is paranoia that is not completely baseless given the general climate. And I will leave it for discussion, the reference to diaspora Jews, which is also a clause that evoked a lot of discussion in the way that the state of Israel sees itself as responsible of the fate of Jews elsewhere. And I will leave it at this, and we'll leave room for the discussion. Thank you.
Thank you so much. Professor Wattad?
Atuva. When the nation-state law was passed, or even prior to that, those who promoted its legislation made several statements about the incentive or the incentives behind such enactment. The first argument has been that in Israel there are enough laws that protect human rights, but there are no enough laws / basic laws that protect Israel's Jewish identity. And it is time for us, this is what they declared, to protect Israel's identity as a Jewish state in a constitutional level. The whole character of Israel as a Jewish and democratic state basically goes back, I would say, to the partition plan of 1947, which stipulated the establishment of two states, nation-based states, one a Jewish state and another an Arab state. Notice, not a Muslim state or a Christian state. Namely, we are not referring here to a religious state, but rather to a national state. And both states are supposed to be democratic states, not in the formal sense of democracy by having elections every 4 years, but in the more substantive meaning of democracy, namely protecting human rights. And there are a special chapter there in that proposal that provided that the full equal civil and political rights of the Arab minority in the Jewish state will be protected, and the full rights will be protected for the Jewish minority in the Arab state. But let us put the partition plan aside because it's not a binding law. The Arabs basically also rejected it. The first and the most important legal document of which Israel has been proud for many years, until recently it seems, is the Declaration of Independence. In 1948, when Israel was not expected to provide equal rights to the Arab minority because Israel was involved at war with its Arab neighbors, including its Arab inhabitants, Israel promised in the Declaration of Independence to be first a Jewish state, the homeland for the Jewish people, and to extend equal rights, political rights, civil rights, and collective rights of culture and of language and of religion to its Arab minorities. The word democracy was not included into the Declaration of Independence, though. And when in 1951, the Supreme Court of Israel was challenged in a constitutional case regarding the right to freedom of speech, Chief Justice Agranat, who is an American Jew, and this is a very important fact about him, because Americans are well aware of the First Amendment and the rationales for freedom of speech, he said the following in 1951: in our constitutional system, the constitutional right to freedom of speech is prerequisite for democracy. And Israel is a democratic state based on interpreting the Declaration of Independence, and therefore we must protect freedom of speech. What constitutional right to freedom of speech in 1951? We did not have a constitution, we still don't have a constitution since then. In 1950, we submitted to the fact that in Israel we basically agree not to agree. Namely, we cannot agree on the basic pillars, fundamental pillars of a constitution, and therefore we better not waste our time in writing a one-book constitution. Instead of that, we were very genuine. We will draft a constitution chapter by chapter. Every chapter upon which we agree, we will call it a basic law. Once we are done with such enactments, we will put all these basic laws together in one book and we'll call it the Constitution of the State of Israel. How many basic laws we were supposed to enact? God knows. What will be the legal status of these basic laws once they're legislated? Are they already a constitutional, normatively speaking, enjoy a constitutional status? Or we should wait until we finish the project and then they will become a constitution? God knows. Well, obviously, as in every country, the first basic law would be basic law, the Knesset. We need a parliament. Then basic law, the government. We need the government and executive branch. Basic law, the judiciary. Basic law, the army, etc., etc., etc. But one of the most important chapters in every constitution is the Bill of Rights. And that chapter we did not have. It occurred to us only in 1992 that we should enact a basic law on human rights. But human rights sounds a bit problematic. There are too many issues to deal about. The first issue would be, for instance, the nature of the state. When you say a Jewish state, what do you mean by a Jewish state? State of halakha, a civil society. When you say democratic state, what do you mean by democratic state? Then they decided that even on this issue of the Bill of Rights, we have to divide the discussion. Let us enact quasi-Bill of Rights on rights that we agree that they should be protected. So we started with Basic Law, Human Dignity and Liberty. The title is so fancy. In this basic law, we included the right to property, privacy, dignity, freedom of movement, but not freedom of religion, not freedom of expression, not equality. And just to, if you are nervous, I'd calm you down. The right to equality was not included there, not because of the Arab issue, but because of Shas, the ultra-Orthodox party. They vetoed, they said, once you include equality, then it might jeopardize the status quo of the rabbinic courts, thus entitling the Supreme Court of Israel the power to intervene and tell us that equality should exist between men and women in rabbinic courts. So their compromise was with Rabin. They will abstain in voting against the Oslo Agreement, and equality will be taken out, and then they will vote for basic law, human dignity and liberty. What is important about this basic law, human dignity and liberty, despite the fact that it's not comprehensive, there are a few provisions there that basically sketch Israel's constitutional regime. First, Article 1 of this basic law, for the first time in the history of the State of Israel, provides explicitly in these words: the State of Israel is a Jewish and democratic state. This is the first time the term Jewish and democratic state appears in our laws in general, in our basic laws in particular. Second, we borrowed some American notions to our constitutional law, and we included the so-called supremacy clause, saying that all governmental branches must respect the rights that are provided in the basic law, which means that this basic law is above the Knesset, it's above the judiciary, and it's even above the government. Additionally, there is a provision called the limitation clause, which mandates that the rights that are protected by the basic law may not be violated, but if the following conditions are met. These conditions include for proper purpose, such as public order or national security or public health. The violation of the right should be in accordance by law, not just by any custom, and it has to be proportionate. And it has to meet with the values of Israel as a Jewish and democratic state. Well, in 1995, the Supreme Court of Israel says the following, and this is Aharon Barak saying that, somebody who knows quite something about comparative constitutional law. He says, in this basic law, you have basically all elements that suggest that we have a constitution. So the normative status of our basic laws in 1995, it was said, he read history. This is how legal scholars read history and interpret history. These basic laws are above ordinary laws. It was called a constitutional revolution. Who didn't agree with him? Those who enacted basic law, the nation-state law. All of a sudden, they agreed that the basic law is above the law. All of a sudden, they think that it is time for us to include Israel's identity as a Jewish state in a basic law, not in an ordinary law. The problem in this regard is that they are pulling our legs. Israel's identity as a Jewish state is protected in a basic law. I just mentioned one basic law, human dignity and liberty, and there is also basic law, freedom of occupation. The law of return in Israel, which was enacted in 1950, although it's a regular law, but the Supreme Court of Israel in 1995 said, before this compromise regarding basic laws, there were ordinary laws that were enacted that deal with fundamental issues such as the law of return and the law on the emblem, the flag, the emblems, the flag, and the anthem. And these laws are equivalent to basic laws. So it was the Supreme Court itself that said that the law of return is equivalent to a basic law. So wait, Israel's Jewish identity is protected in the constitutional level. The anthem, the flag, and the symbols are protected in the constitutional level. The law of return is protected in the constitutional level. Jerusalem, the capital of Israel, 1980. Basic law, Jerusalem, the capital of the state of Israel, provides explicitly that the entire united Jerusalem, while you were talking, I checked the language, it says the entire united Jerusalem is the capital of the state of Israel. So what is new in this law? Nothing is new in this law. This is basically a reenactment of already existing laws in Israel, and this is not the first time that the current government does that. There are obviously many political reasons to do that. So to that extent, I am not nervous by what is included in this basic law. What concerns me more are two things. One, what is not included. And second, the consequences. I'll divide the discussion of this into two stages. I say what concerns me more is what is absent from this law, not because the word equality is not there. I mean, obviously we have the Supreme Court, alike to your Supreme Court, you said in Brown versus Board of Education, the Equal Protection Clause includes dignity. We say in our country, the right to dignity includes equality. Period. That's easy. But what concerns me in this regard is that you keep telling me, the politicians, that we don't have enough legislations in favor of Israel as a Jewish state, and we do have enough legislation in favor of Israel's democracy. The truth is that we do not have enough legislation, if at all, that provides for the position that Israel is a democracy. Actually, and to be honest, if it was not for the Supreme Court that created these rights out of interpretation, there are many fundamental rights that are not protected in Israel. In 2021, the right to freedom of speech is not protecting in any single law in Israel. In any single law, and I'm not even talking about basic laws, there is no single law that says that freedom of speech is protected. It is only because of that precedent in 1950 of Chief Justice Agranat that said in our constitutional system it's prerequisite for democracy, that freedom of speech is protected. And then afterwards, the court said it is part of dignity because we borrowed this idea from Dworkin, the philosopher, that dignity includes protection for freedom of speech. So if we have enough sources and enough time to issue new legislations about basic, instead of investing this time in reenactments, how about I think in Israel we all agree that we need freedom of speech. Israel, by the end of the day, is a democracy. So why not to enact basic law? Don't enact, amend basic law, the human dignity and liberty, and include their equality. Not for the Arabs. This is not the only, for women in Israel. We succeeded in Israel to appoint a woman to be a judge in the Sharia courts. Shas agreed to vote in favor of such appointment, but on one condition, that this shall not serve as president for rabbinic courts. Seriously? The second thing that I was talking about, and let me just in a footnote say here about basic laws in Israel, even though we deem them to be a constitution or quasi-constitution, it's a limping one. Because unlike a constitution is basically entrenched. It's hard. You need special majority in order to change it. Our basic laws, by large, can be changed by any majority of 2 against 1. Apart from one basic law, freedom of occupation, and some provisions in some other basic laws. Basic law, the judiciary, the most important basic law that gives power to the judiciary, can be removed from our book of legislation. Basically, human dignity and liberty has no protection at all. If the government, if the parliament wants tomorrow morning, it will be vanished. And I'm not exaggerating. Of course, we have many diplomatic reasons not to do that, but it can be. Now, the other thing is the consequences of this nation law. The fact that I'm not nervous is because I'm a law professor. With all modesty, I'm not considered the lay person in my society. But the lay people in Israel perceive things without reading the provisions, without knowing that we're talking about reenactment, without thinking about the question whether this law is more of a declaration rather than an operative one. Arabs in Israel perceive themselves to be second-class citizens. Actually, they cannot argue that they are being equally treated because Prime Minister Benjamin Netanyahu, Prime Minister Ehud Barak, Prime Minister Ehud Olmert, Prime Minister Sharon, Prime Minister Rabin, and Peres as well, all of them made a statement that the Arab community in Israel has been institutionally, historically discriminated against. So if they argue that the Arabs have been discriminated against, you cannot expect Mohammed to say, no, I have not been discriminated against. And on the ground, actually, the current government should be proud of itself because it's one of the few governments that have taken steps towards equality in terms of economics, for economic reasons. I mean, Naftali Bennett and Benjamin Netanyahu stated this straightforward. They said the Arab minority could be an economic power in Israel, and therefore we have to give them sources. And then they came up with the 5 years plan and allocated a certain great amount of money for this plan. But also the lay persons in the Jewish community don't read the provisions of the law and not aware of the sophistications that we are talking about them here. For them, the self-legislation of the law alludes that Israel is becoming a more nationalist state. And once we talk about nationalism, you know what nationalism means. I mean, it's one thing to have national aspirations of establishing a state. It's another thing to speak of nationalism. People usually, when they talk about nationalism, they become patriotic. Patriotic not in the sense of loyalty, but patriotic in the sense of extremism. the day after the nation-state law was passed, and to be honest, I'm not sure what I'm going to tell has direct linkage to what happened, but it happened. 4 young doctors, physicians, were walking on the beach in Haifa. Then 2 Jewish youth approached them and asked them, are they Arabs? They said yes. They went back, brought their friends, come, and beaten them to the extent they needed to be hospitalized. Now, again, because I'm too much serious about my arguments, I don't want to draw a direct linkage, but the general atmosphere is changing. If you keep telling me that the Supreme Court of Israel imposes threat to the self-existence of Israel, then you are basically threatening the Supreme Court. How come that a minister of justice dares to say to the Supreme Court that if you don't dismiss the petitions against the nation-state law, then an earthquake, a political earthquake, is going to happen? This is the kind of language that we use when we talk to our judges? And then we expect people to respect judges? Remember, we're talking about the judiciary. It has no budget. It has no way of executing its judgments. It's all a matter of trust. So I am concerned. I am very concerned, not for the short run, but for the long run. I am concerned because in the daily life, all research, empirical research in Israel, provide that the Arab minority in Israel is willing to live inside Israel as Israel, being a Jewish and democratic state. Actually, recently I learned that 70% of the Arab minority in Israel have no problem with Israel's defining itself a Jewish and democratic state. Do I still have time? Like a minute or so? I'll just conclude. A Jewish state is a state that grants every Jew in the world a golden key. Being a Jew, you can open the door of the state of Israel and enter that state. But once you become a citizen of the state of Israel, you have no extra rights. You should be treated equally compared with all other citizens of the state. That's exactly the balance that the Supreme Court of Israel has been trying to strike for 70 years, a very sensitive one, saying that the Jewish characteristics of Israel do not necessarily contradict its democracy. And now they're trying to say by this new law that no, Zionism does not fulfill the values of democracy. I don't agree with them, but this is what they're trying to say. Judaism does contradict democracy. This is what they're trying to say, and therefore they want Jewishness to prevail over democracy. I say no. The universal aspects of Judaism they go hand in hand with the universal aspects of democracy. I don't want to teach you. I don't need to teach you. I'm quite sure you know more than I about the values of Judaism and of the Hebrew heritage. So let us move now.
Thank you. Okay, even though I'm going to, by the way, go Israeli on us and use first names, dispense with formalities. Even though Ari spoke first, I'm going to ask Mohammed a question to follow up on what he was saying, and then I will turn to Ari. You both lay out very extensively and beautifully the problem and also the basis of confusion and the conundrum of Israel not having a constitution but having constitution level laws And Mohammed makes the astonishing point, astonishing for those of us who have been sort of subjected to the barrage of criticism of this law in the media. He makes the point that at the end of the day, it really isn't that different from, restating what already existed, both in legal terms, for instance, restating the 1980 law statement on Jerusalem, and on, and also the attitude toward the judiciary and setting the basic laws above the judicial branch, etc. So why are we here? Right? Why are we here if it is simply restating, maybe in a different order, most of the precedents that already existed? And I think that you make a very, very good case for explaining why it's different, why we are here, and that is because the atmosphere has changed. The use of these precedents that already existed, the eagerness by certain parts of the government to exploit loopholes and lack of language guaranteeing personal liberties, that has expanded perhaps. And that really the legal situation may not have changed, but it's merely more of a political reality. So I'll ask you gave a beautiful legal explication, and Ari gave a beautiful historical outline and explanation for why these laws developed this way. But what I'll ask you then is, how do we then translate it into political realities on the ground, or practical realities that will perhaps treat them differently if what is really different now is the atmosphere and the use of these laws?
Thank you. See, in Israel, we have our school of thought concerning legal interpretation. When we interpret a text, we go to the purpose of the text. We don't look necessarily to the intention of the founding fathers, as in America. This theory is valid so far we are talking about an old legislation. But once you are talking about legislation that was enacted yesterday, you cannot ignore the intention of the framers. The intention of the framers is not vague. Bennett and Ayelet Shaked are telling us our intention is that once at stake there is considerations of democratic values and considerations of the Jewish identity of Israel, the Jewish identity of Israel prevails. Now, taken together with the fact that the government has been leading serious attempts successfully in amending the way judges being appointed to the Supreme Court and succeeding to put in the Supreme Court justices of their like, namely, they think in the same way. And you give them this means that is called nation-state law. Call it the basic law, namely all other laws are supposed to be interpreted in light of that basic law. With the clear intention of the framers, the case will be easy towards changing all precedents provided in Israel. I'll give you examples. You want to go to practicalities. To be honest, there has been no single law in Israel that provided that Hebrew and or Arabic and or English are official languages. This was a mandatory law from the British Mandate that said that all laws should be published in Hebrew, Arabic, and English. If you understand from that Hebrew is official, then you should understand that Arabic and English is official as well. Now, in the early 90s, an NGO, an Arab NGO in Israel, challenged the court concerning traffic signs, asking to issue a decree that forces the government to publish the traffic signs in Arabic and in Hebrew. Well, traffic signs is not exactly a legislation. So the court said, well, the law, this mandatory law says a legislation must be published in all 3 languages. It doesn't speak about traffic signs. So Aaron Barak was creative enough to say that for the purpose, for the sake of this case, let us say that there's a word there, formal notices, then traffic signs also formal notices. And I will apply this decision only to mixed cities in Israel, not to all cities. Jerusalem, Jaffa, Haifa, Lod, and some other mixed cities. So to that extent, Arabic has not been really an official language in Israel, although in practice it was, because you could go to court and speak in Arabic. Now what happened with this new law is that it says Hebrew is an official language, perfect, no problem with that. Arabic enjoys a special status. God knows what special status means. It's either official or not official. But assume that they are degrading now the status of the Arabic language from official language to a special status. There is subsection C, you can see it in Article 4 there, that says nothing in this basic law shall affect the previous status of the Arabic language prior to the enactment of the law. This is self-contradiction inside one provision. So why to make that? In order to satisfy certain segments, political segments in Israel, right? To create a general atmosphere as if something happened, like we sound patriotic, only Hebrew is the official language. No, you are saying that Arabic also is an official language in subsection C. And to put the finger in the eyes of the Arab minority. Ladies and gentlemen, let me make this clear. With all due respect, you won't hear many Israeli Arabs saying that Israel is a Jewish state and democratic state, and it shall remain a Jewish and democratic state. I do say that explicitly in Hebrew and Arabic and in English. But we should be aware of also one important fact. The Arab minority of the state of Israel are not immigrants in Israel. They were born there. They're indigenous people. They have culture. They have heritage. The language is not just another language. They did not migrate to France and therefore they must speak in French now. Actually, it should be important for the state of Israel. There's a great amount of Jewish people, Israeli Jewish people, who speak Arabic because they came from Arab countries. And if we talk about coexistence and shared societies, then we should learn the language. When you learn the language, you respect the other side. You understand the close sentiments of the society when you understand the language. You know, I found it a bit, I'm sorry that I spoke a lot now, but it's really an important point about language. You know, there's an Arab soccer team very successful nowadays in the Premier League in Israel. It's called Sahnin. Now, when they score goal, the fans, they say, Allahu Akbar. Allahu Akbar, God is great. Elohim Gadol, בעברית. Once you say Allahu Akbar in Arabic, people are scared. Well, why do they say Elohim Gadol? Say, God is great. This is the same language as in Hebrew. But because you are not close to the sentiments of their language, of their culture, language reflects on your culture, it affects you. No one is against Judaism. The Star of David is close to me exactly as it's close to you. As a Muslim, I believe in Dawood, David. Who is Israel, by the way? Jacob. I believe in Jacob. I must believe in Jacob. So it's not just about going to court or to an official office and they tell you can't speak in Arabic. To the contrary, it is about telling you that if you want to buy a piece of land, even if it's a public piece of land, you cannot do that. The Qadan case spoke about lands owned by the administration of the Israeli lands. It did not speak about the Jewish fund lands, which are quite private and could be sold only to Jews, and they are sold only to Jews. Once I start moving in the street, once I approach official offices, after this law, and because of the atmosphere that it creates, people look at me and they don't see me, just me, although people keep thinking that I'm Haredi, although I don't have a black kippah, but they keep thinking so. People see Mohammed, they see what I am, not who I am. My students might start treating me as what I am, Mohammed, regardless the fact that I'm legal professor or whatsoever. And this is what really concerns me, how the lay people understand things, and then how the sophisticated people in politics and in government take things to their side.
I want to remind people that I got a few index cards with questions already, but we have the people in the back who are collecting cards. If you would like to write down a question, you can raise your hand and give them your card or ask for a card, and I'm collecting them. So I have one more question before we turn to audience questions, and this is for Ari. You talk about the responsibility that is stated in this law, in this nation-state law, of the State of Israel, where it's stated that the government is responsible not only for its citizens, but for any Jew outside the State of Israel or any Israeli citizen, including Arab citizens of the state, if they are in danger or attacked outside of Israel. So this is sort of, an interesting combination. It's a composite animal. On the one hand, we're talking about Israeli citizens, no matter their religion or their ethnicity, that the state takes responsibility for safeguarding their security. And so that if Mohammed is in London or Paris and is, or God forbid, Washington, and is attacked by virtue of his being an Israeli citizen, if someone knows he's Israeli and expresses that they are attacking him because he is an Israeli, then the Israeli government is pledged to protect him and to, if necessary, bring to justice the people who have attacked him because he is Israeli. But because he is Israeli. We'll discuss it. We'll let the speakers answer that. But at the same time, the Israeli government has pledged, since the creation of the state, that it is there to protect Jews no matter where they are in the world. And as an historian, Ari, a fellow historian, and as a Jewish citizen of the State of Israel, so you kind of hit all of the all of the categories. Looking at this from a historical perspective, on the one hand, many, if not most, Jews in the world would say that this is a defensible position, the latter aspect of being there to protect or to serve as a refuge for any Jew. Look, the rise of modern Zionism came about during a fraught period of time for Jews who were experiencing pogroms in Eastern Europe. The State of Israel was proclaimed, as we know, immediately following the darkest chapter in all of Jewish or arguably human history, in the Shoah. And even today, we have populations of Jews around the world who say that they might go to or have been going to the State of Israel because of anti-Semitism. So in the eyes of many, including many very liberal Jews around the world, this is a defensive position. But how do you then reconcile this with the stated purpose of being a democratic society as well?
Thank you for asking me a question, but I'm the last one to try and rescue a legal text that is so confounded with internal contradiction and impose a systematic coherence on a text that, as we just heard, is contradicting itself. So the confusion that we hear here is indicative, and we're in that respect a bit in a good company, because I think that I agree with you completely that when we want to understand the what's so problematic about the law, we need to go beyond the text and understand toxic environment that provides the background to this recent legislation, and the fear that it will fuel future developments. Now, no one, the clause, the specific clause you're referring to, I will use the Hebrew version first, and then try to translate it verbatim as we go. המדינה תשקוד על הבטחת שלומם של בני העם היהודי ושל אזרחיה, הנתונים בצרה ובשביעה, בשל יהדותם או בשל אזרחותם. So the state will do whatever is possible to secure the safety of members of the Jewish people and the citizens that are tzara shviya, in prison or in stress, literally, due to their Jewishness or due to their citizenship. So in a way, they're trying to cover all of it. And now one can reverse the question in the following way. So yes, it will be very unlikely, and a judge needs to be extremely creative and ignore parts of this specific clause in saying, let's say, God forbid, Mohammed is in it was kidnapped in Washington, D.C. It's a dangerous place. And the message comes to the equivalent of the Israeli State Department, and they will first check if he's a Jew and a Muslim or a Christian, and then decide on how to act to save him. So that will be a very unplausible, scene that the judge will say, this is the way to go. It does, we can take it the other way around, and it does imply, now I will be, for a second, I will play the Israeli snob. As long as I lived in Israel, I pay taxes. Why should my taxes need to go to help a Jew that is not a citizen of Israel, that is not paying taxes? So there's a bit of a circular argument here that is of course can be understood again, a longer tradition that one can go all the way back to the 1840s and the Damascus affair, that Jews are trying to help their co-religionists that are in stress elsewhere. And the legal, code tries to find some sort of a way to express the sentiment, but it's definitely a bit of a problematic. It's a clause that, in a sense, is I think yet another example of saying nothing in so many words, but that the effect is more. Using your words is about. The compound impact is of pushing the non-Jewish population of Israel, which constitutes 21% of the general public, into a position of feeling alienated. And I think that moving from the interpretation of the law to the immediate reactions, I think one can see the confusion. One can see the confusion among Israel's Jewish citizens. I was in Israel on August 19th when there was a massive demonstration that was called in the Rabin Square in Tel Aviv, formerly known as Kikar Malchei Israel, now named after Rabin, that was assassinated there. And you could see both in the slogans that were used, both at the level of the organizers and in the crowd, that there are like conflicting messages, and they're trying to understand what they're protesting for or against. Are they protesting for equal rights for any citizen of Israel, or they are very upset on behalf of the Druze community, Arab speaking but serving in the Israeli Defense Forces, that they felt extremely alienated, rightly or wrongly, but that was their sentiment immediately, less than 24 hours, that this law places them at the degree of a sort of a second-degree citizen. That was the perception of Druze officers, and in a way, it was an interesting, I was torn between being a participant and observer, but being an observer, it was hard not to see that there's a mixed sentiment that it will be played out in the years to come. One of the messages that, on the one hand, sound, I think the Druze case is indicative not of the legal status, but of the confusion that is so is so prevalent in Israel today. One of the things that was there was a famous poem that was written in the 1970s, in 1974, by an Israeli popular singer, a songwriter and poet named Yonatan Geffen. Incidentally, he's also the nephew of Moshe Dayan. But in 1974, there was a case that no one remembers today, but it was a terror attack in Kiryat Shmona, the northern city bordering Lebanon, and a combat, an elite Israeli, a Sayeret commando unit stormed in. One of the first ones to be injured severely was a Druze combat soldier, and it really impressed Jonathan Geffen, who was an officer in Golani himself. And he wrote a poem that is called Balad al Druzi, a ballad for the Druze. It plays on the pun between Uzi, the Israeli Tommy gun, and Druzi, that sound similar. And the poem, tells the story of how in the little Galilee in the Carmel, here came to birth someone that was loyal to Israel. He learned the Prophet Mohammed for 2 hours and then 2 hours Zionism. When he came to military conscription age, he volunteered not simply to the army but to the best combat unit. His commanders looked at him, what a great soldier, and underneath the dubon, that was the typical Israeli military coat, and the Uzi, no one knew that he is a Druzi, and that was the repetitive thing. Now, people took this poem for obvious reason, dusted it off and brought it back in. It's an interesting story, and even suddenly the Israeli radio found this soldier that told his story and told how when he was hospitalized in Kiryat Shmona and his family members came to visit him, they were dressed with the traditional Arab keffiyehs, that they were beaten up, and so on. And that was seen as a song that shows you the impossible situation that this law put us in. So again, it's not maybe the law itself as much as it is interpreted by the larger, in the general population. So I think that this anecdote, and I will finish with it, is indicative of the confusion. I found it extremely problematic to endorse the sort of Geffen poem as a hymn for equality. Because actually what the implied message behind it is that rights are privileges that are given only through a test of loyalty through military service. Equality is not something that is given to any citizen by virtue of birth and being a human being that is a citizen of Israel. You need to show your special status vis-a-vis the law. And if that is the case, and a new law, and that was the suggestion, that we will have a special law for the Druze community, and I mockingly called it Donatio Binyamini. This is the present that will come from Emperor Benjamin Netanyahu. He will decide that this group are unique, and that group are... opens the gate to something that is almost a quasi-feudal system of law. The emperor decides that this is the court Jew he likes, but these ones are the ones that are... And this opens the road to something extremely dangerous.
So speaking of diplomacy and Netanyahu, yes, I used those in the same sentence. I have some questions from the audience. First of all, for either of you to answer, can either of you elaborate on the land and settlements aspect of the basic law, and specifically, to what degree might this impinge on the possibilities for a two-state solution? the fact that there is a provision there that ensures Jewish settlements, and is it clear whether the use of settlements refers specifically to the West Bank or just to sort of towns in general? And what are the implications for diplomacy and two-state solution? Do get out.
First of all, the words of the provision do not limit themselves to settlements inside Israel. If this is the case, that they are limiting themselves to the settlements of Israel, namely to Judaize the Galilee, for instance, it's problematic. I mean, I am part of this nation. I don't have other country but the state of Israel. I pay taxes to the state of Israel. By the way, the law does not exempt me from military service. It's just the commander-in-chief doesn't send me draft notice. No, seriously. I mean, we don't need a new law to say that Arabs should be drafted into the army. They are, by law, supposed to, they are supposed to serve in the army if they receive the draft notice, and they don't receive the draft notice for clear reasons. But in any case, that's one thing. Another thing, if the law speaks also about settlements outside the country, namely, for instance, in the West Bank, it's also problematic because according to the official position of the State of Israel, not my position, of the State of Israel, the settlements, the justification for the settlements is security ones. But all of a sudden, by this law, we are talking about ideology. It's not about security reasons. So he who should decide is the state itself, the government itself. About the two-state solution, I leave it for Trump to decide on this issue.
You're the legal expert, and I think I cannot but agree. I think that the question of settlement that always occupies so much of our attention, again, the historian in me automatically think, I mean, a lot of the questions about the legality and illegality of the settlements and how to phrase it, it has a history. It was under the Reagan administration that it was a decision that the settlements will no longer be considered in the official diplomatic language as illegal, but only as obstacles to peace. So, I mean, so a lot of these things have a history. Now, in a sense, again, the historian in me says, those of you, and I include myself and most of those I see in the audience, we remember the Reagan years. We already lived through a period that was a very strong neoconservative trend. That was, you had Reagan here, you had Maggie Thatcher, the Iron Lady in Britain. You know, we've lived through ages that there were a strong shift to the right. I think that it's my feeling that we are part of it. And the situation we're dealing with has a local dimension and a global dimension. Things that sometimes are cold in one place in Israel become a flu. And the symptoms are more severe. But there is a bit of a general trend here. So I think that this is part of it.
I'm realizing that that a number of the remaining questions actually have to do with a similar strain of thought, and so and that will be the last question that I read. So to introduce this question, which has to do with the role of Americans and American Jews in particular, I'll just go back to what I promised before, which was a little bit of an explanation of how this law relates to the position of diaspora Jewry, and in particular non-Orthodox diaspora Jewry within the state of Israel. So the bill and then the law promises that the state of Israel will, quote, work in the diaspora to preserve the bond between the state and the members of the Jewish people. Now, what could be wrong with that? This phrase was very carefully worded to prevent the worldwide progressive Jewish community from being particularly active and from being recognized inside the state, so that while it actively, the law encourages actively working, in theory, to preserve bonds with the Jewish community outside of Israel, that doesn't mean that they necessarily have to have their agendas honored, or often even their members recognized as Jews, for instance, if they do not receive Orthodox conversion inside the state of Israel. So it makes a distinction between inside and outside. We've seen this in recent acts in legislation, and also in certain news items in Israel with since the passage of the law, with, for instance, Israel rescinding a law that allowed gay couples to adopt babies through surrogacy. And as many of you have probably heard, several weeks ago, a Masorti or conservative rabbi in Haifa was taken in for questioning to the police station and interrogated because he had, some years earlier, performed a conservative wedding inside the state of Israel, and that is against the law. So, diaspora Jews, and particular American Jews, are, I might say finally, sort of waking up to this great discrepancy of inside and outside and how they're being treated. So that is a matter of great concern for many people outside of Israel, and also obviously for the liberal communities inside Israel of Jews. And to the extent that the left-wing Meretz party in the Knesset put forth an amendment to change the bill and then the law to change the name from Israel, the nation state of the Jewish people, to Israel for Orthodox Jews only. So that then is sort of a lead into the question that several of you wrote on your cards, and as I said, this will be our last formal question because I know that I'm sure you want to eat again. So the question is, what possibility does either of you see for making changes to the nation-state law, and specifically, what role do you see American Jews or diaspora Jews playing in encouraging these changes? Silence.
It's a tricky one because I mean, laws, unlike the web pages we read, I mean, the specific law that we are discussing this evening does not include the halachic definition of, under Jew, look, the definition. It's not, there's no hyperlink that leads, from the word Jew in this bill to a different entry that will provide you the orthodox definition of Jew. This is, again, something that in order to understand it, you need to bring in both other laws and general interpretations throughout the ages. And again, the legal field will be left, outside here. The final, part of your question is American Jews. What the American Jewish community, how it plays, if at all, a role. I mean, it's very hard to talk about it in such a monolithic term. There are definitely different colors, shades, approaches. I know that the desire to eat after my talk is something probably that unites both Reform, Orthodox, and conservatives. But as I always tell my students, when I'm teaching the history of Zionism, put two Jews in a room, you'll have already 4 opinions. So it's very hard to me to talk about a monolithic American Jewish community. I think that there are definitely some individuals that are coming from the American Jewish community, including an owner of a specific casino in Vegas that has a huge impact on Israeli politics, more than all of us combined, and it's undeniable. But this is not the legal landscape per se.
Ask the state of Israel to treat its minorities with the same standard that it expects the Jewish minorities all over the world to be treated by their governments.
I would let that be the last word. Thank you so much for coming. Thank you to Ari and Mohammed, and again to Washington Hebrew and AU Center for Israel Studies. And Moadim L'Simcha, happy Sukkot, and B'tei Avon, and enjoy your food. Thank you.
Thank you very much.